Well, welcome to Protecting Your Client and Protecting Your Program. This is basically a risk management presentation, and it's designed to remind us, alert us to the importance of protecting our program while we're protecting the client. So as we move through this, we will be investigating these two prongs of what I'm going to call your duty of care. That is, protecting the client and protecting the program. This is a disclaimer simply saying that I am not, by virtue of my professional licensure, entitled to opine on laws of other states. I mean, I will do that, but only generally. So talk to somebody local who knows your outfit and your state laws. And of course, I'd be happy to work with them, but it might not be necessary. Okay, understanding your legal duty of care. Let me just explain at the outset. This is a fairly complex and immensely important concept to get. And I will say, by way of sort of spoiler alert, you clearly have a duty of care to somebody that pays you a fee to do something for them or to them. The issue really is, in your case, not so much do I have a duty? You do, but what is the nature of that duty, and how will I be measured in terms of performing the duty? So, duty, as I say in this slide, is a big deal. And it's a big deal because it's the linchpin, I'm going to call it, of a claim of negligence. And negligence is probably going to be the basis of a claim that is filed against you. You may be sued for breach of contract. You could be sued for violating local ordinances or regulations. I guess you could be sued for assault. Generally, though, negligence is what you're going to be sued for. And you can't get sued for negligence unless you have violated your duty. So I'm going to read to you, last time I'll do this, I hope, that your failure to meet a legal duty of care is at the core of a suit for negligence. And next slide, here is what negligence is. A plaintiff, that is the person bringing the lawsuit, the person who claims that he or she has been hurt. Plaintiff in a negligence action has to show a duty of care was owed, that the duty was breached, in other words, the person didn't meet that duty, and that the breach caused a loss. So a duty was owed, the duty was not followed, there was a loss, and the loss was a result of that breach. Usually, duty is an after-the-fact analysis. In other words, the bad thing has already happened. And you are either analyzing your responsibility, or a judge is doing it. And an important aspect of duty is that whether or not and how you performed your duty will change variously, let me just say that, over the course of your relationship with your client or student or whatever, as the circumstances change. I would also say that it's pretty good to have your staff understand that they do have a duty of care to the people that they are handling, and help them understand what that duty of care is. Now, there are certain factors, just universally, in determining whether or not a duty exists. In other words, you don't owe everybody in the world an obligation of any sort. We're talking legal duty of care. We're not talking any moral or ethical or religious obligation. This is a legal duty of care. And a legal duty of care arises out of relationships and the foreseeability of the thing gone wrong. So as I say here in this panel, the initial inquiry regarding duty is, was there a relationship between the parties so that the plaintiff, in your case, let's say your client or student, so that the plaintiff might suffer harm if the defendant, that might be you, acts or fails to act in a certain way. So a relationship and the possibility of harm or foreseeability. Now, just to bring this home a little bit, most of you know of the suit filed by a Munn family against the Hotchkiss School a couple of years ago. It came out of a tick bite suffered in China by a 15-year-old child who was on a Hotchkiss school trip. She became terribly ill shortly after this bite and basically was rendered a quadriplegic, although she recovered from some of the original paralysis, I understood. But she sued, and the jury came in with a over $40 million verdict, claiming that the Hotchkiss School should have foreseen this harm suffered by this child, should have foreseen that the child would be bitten by a tick and suffer from tick-borne encephalitis. The case is now on appeal. And one of the things that is being argued by Hotchkiss, they couldn't possibly have foreseen that this sort of thing could happen. The jury saw it otherwise. Clearly, there was a relationship between Hotchkiss and the student that created a duty of care. Now, in addition to a relationship and a harm that could be reasonably foreseen, another aspect, and this comes up in the Hotchkiss case too, is treated at item 2 in this panel, and that is a public policy test. It's interesting. It basically allows a court to just put aside any issues of duty or foreseeability and say, look, under the circumstances, in this case, the interests of society are better served if, usually what they're doing is interrupting duty, if I find no duty here. They can go the other way too. But generally what we deal with is the prospect of a court deciding that whether or not there's a duty, whether or not there was foreseeability, the interests of society in this circumstance are best served if we find, one way or the other. In the Munn case on appeal, what Hotchkiss has said is that the interests of society in middle school travels and adventures abroad is so great. In other words, it is such a valuable experience for young children that there should be some easing off of traditional notions of negligence. I don't know if that'll work. We'll talk in a few minutes about another public policy issue involving releases, and maybe this will clarify a bit the situation if I haven't been clear here. But again, factors in finding a duty, a relationship, likelihood of harm, and this overarching public policy consideration. Now, if a duty is owed, in other words, if the relationship is such and the foreseeability of the harm is such that a duty exists, then what is the duty? And I do want you to read this very carefully. It reflects what we have referred to as for ages as the reasonable man test, but of course, somebody finally got smart and said it's really the reasonable person step. And so the duty is to act reasonably. You'll see how important reasonableness is in this description of duty, to take reasonable steps to keep from hurting somebody. And this is important because it refers to what you and I do. In some relationships, the duty is to protect another person from unreasonable risks of harm, not simply not to cause them harm, but to protect them from harm. The kind of relationships that invoke that obligation to protect are identified as those which are custodial and fiduciary. I'm sorry to be throwing so many terms at you, but you'll very quickly see us in this. Relationships that are custodial are relationships in which basically control is turned over to somebody else. So the families and our participants turn themselves and their children over to us, and they trust us. And trust is the second, the fiduciary aspect of the relationship, from Latin fides, faith. They have faith in you to deal well and reasonably with their child. Great deal of reliance and surrender of control in this category of duty, which includes one of protecting, not simply not causing harm. Got it? Now, there are ways to reduce the legal duty of care, and much of this you've had some experience with. I'll take them one at a time. I'm not at A. I've learned, I think, that very often it is as important, maybe even more important, that you be clear about what you are not willing to be responsible for. In other words, be as clear about what you are not going to do as you are about what you expect to do. Same thing about warnings. In your material, it can be at your website, in your marketing material, it can be in your release. Be very, very clear about those things which you cannot control or don't intend to have responsibility for controlling. And then warn people of things that might surprise them. Another method of reducing the legal duty of care is to identify who it is that will be responsible for certain things for which you're denying responsibility. This comes up when services are being performed by an independent contractor, for instance. Generally, you are not responsible for what somebody who is an independent contractor to you does. But you got to be darn clear that they're an independent contractor, and it's got to be clear to your client that they are. And so what I generally say is certain services will be performed by independent contractors, and you must look to them and not to me for any complaint that you have about their performance of services. Releases and waivers, basically there's a slight difference in those terms, but we all use them interchangeably. And there's some limitations. For instance, in most states, a parent cannot release a claim for a child. And I know you see these, I see them every day. They're not allowed in Texas, and yet I'll go to kids' parties or other events, and often you will find specifically a parent being asked to release a claim of a minor, and it just isn't legal in most states. I could probably, with a little care, knock off the 15 or 18 that do allow it. Massachusetts does, Connecticut in a kind of strange way, Florida in a strange way, Ohio, yes, Colorado, yes, Alaska, yes, California, yes, and there are 5 or 6 others. Some states don't allow releases for negligence of any sort, and that would be Louisiana and Virginia. And some states are just very hard on releases, such as Connecticut, and recently Oregon, and there's a little problem in Vermont. Again, you need to talk with your local lawyers and see what's going on in your state. A very interesting aspect of the release in the Hotchkiss case was the language that they chose to use. They thought in being very generous with the families. What they intended to say was, we will be liable if it can be found that we are the sole cause of the accident. Now, frankly, it's maybe difficult under many circumstances to find one and only one cause of a loss. But Hotchkiss was intending to make a concession to its school families. An awful lot of outfits don't. But the court found that language was confusing. The court said that language is just as likely to be interpreted as Hotchkiss being willing to be responsible to the extent it is solely the cause of the problem. I worked with them after the fact with a really good team of good lawyers to modify that release, and I think we did, and clearly it needed a little bit of work, and what we said now is that Hotchkiss is willing to be liable if it and only it, no other person, no other agent, no other circumstance contributed in any way to the loss. I mean, that was what they had intended to say. Courts don't like these things usually, and they interpret them very strictly. That is in favor of the client. So you really got to get those things right. Another way of reducing the duty of care is by an expressed assumption of the risks. This pops up often in helmet situations. The person says, yes, I understand the helmet could reduce the chances that I might be hurt, but I'm going to do this anyway. There are techniques for implicating minors who are legally incompetent to make agreements into all of these reductions of legal duty. I mean, I generally have the parent who signs the document saying that the parent understands all this stuff and has explained it to the kid, and the kid wishes to participate in any event. It's awfully hard for them to say later that the kid didn't have the faintest idea that gravity works in Oklahoma, for instance. And then finally, I'm down in D, another very important, and I'm going to develop this further, manner of reducing the legal duty of care is to demonstrate that what went wrong as a result of an inherent risk of the activity. An inherent risk is one that simply comes with the territory. It is such an integral part of the activity that if you took it out of it, the activity would be something else. Falling in rock climbing, falling off a horse, falling into a river or stream in a rafting case, a trip and fall on the trail. But if you enlarge the inherency of that risk, then you're right into the negligence bucket. Again, in a recent wall climbing case out of Ohio, for instance, a woman dropped her boyfriend on a climbing wall. He got 5 or 6 feet of slack. She was not paying attention. He fell and she didn't catch him in her gree-gree. But the court ruled, hey, falling's an inherent risk of climbing. You probably wouldn't climb if there weren't the exhilaration of not falling. Now, if the woman had simply taken her belt off, or if she were drinking a Coke, if she were on her phone, I mean, that clearly is not an inherent risk of being belayed in a wall climbing situation. All right, so we have a duty. We've explored what can be done to reduce or eliminate that duty. I should have mentioned something else about releases. You cannot, except in the state of Florida, it appears, be released for gross negligence or recklessness or intentionally wrong conduct. Limited strictly to negligence in every state, but I believe Florida. Okay, so you've got a duty. You've explored how you can reduce the duty. Now we reflect on the circumstances of the accident, and we asked ourselves, by what standard will my staff be judged in this circumstance, where there was clearly a duty, and was the duty fulfilled? And the standard is, as I have written here, to act as a reasonable person would have acted under the same or similar circumstances. Now, If you purport to put somebody on a climbing wall, or to cross a stream, or to hike through rockfall or timberfall country, you are expected to act to a certain degree of, I'm going to say, professionalism. But another term we can use, I guess, is reasonableness. But the test again is, what would and let's pretend that a bad thing happened to one of your programs. What would a reasonable program like mine have done under the same or similar circumstances? Did my staff act as a reasonable staff doing the same thing would have acted? Now, as I note at the bottom, there are two really important aspects to this piece of law: the objectivity first, and the test of reasonableness. Objectivity, it isn't this person, the actor, that they concentrate on. It is this fictional, reasonable person out there. And so your staff member's conduct is going to be judged on how this fictional other reasonable person would have acted in the same circumstances. I mean, what usually happens is that you get experts come in and they argue on both sides of what a reasonable person would have done. And there can be references to standards, to in-house practices and policies. Those things usually create, if they're violated, a presumption of negligence, but it's not the end of the story. You can still come in and show under these circumstances, even violating that standard was reasonable, and how the standard could be unreasonable. Second, I'm now in note B, is reasonableness. And this is important because I hear so much now about best practices, and it really is a very dangerous term. This standard does not require, as I say here, perfection, nor best practices. It is simply reasonableness. And that's very important and ought to be of some comfort to all of us. Okay, so ends the section of this presentation on duty of care. Let me say too that I am happy to talk to anybody who sees or reads this. If you'll call me, I'm really good for about half an hour, and then I start getting fidgety. But if I can help you understand some of this, I'm happy to do it. All right, I'm moving now to something called the Doctrine of Primary Assumption of Risks. This is a tremendously important concept for us. Read this first piece. Remember, I talked about inherency of the risk being a limiting factor on duty. In sports and in recreation activities that encourage and are best served by vigorous participation, these inherent risks are assumed. And as I said, the service provider has no duty to protect people from inherent risks. The kicker is this next sentence. And I'm going to go out on a limb here and say most states will include simple negligence of co-participants and instructors and organizers in those inherent risks. In other words, what is happening here could not happen without the risk that somebody might be careless. Now, it doesn't cover gross negligence. It doesn't cover mean-spirited or intentionally wrongful acts. But in these states, in sports and recreation activities, negligence is tolerated. Now, different states that have adopted this negligence is okay sort of standard will restrict it to certain kind of activities. But generally speaking, what seems to be going on here is that activities which are communal in nature, in other words, there is participation by a group of people, and site-based, or at least they're doing it together at a place or at a location that's more or less designed to attract people for that purpose. And again, if it is something that calls for vigorous, active participation, there is going to be this kind of forgiveness. The forgiveness of negligence has been upheld in uh, games of a variety of types. I mean, certainly hockey, baseball, football, uh, lacrosse games, climbing, wall climbing. I mentioned that Ohio case earlier where the woman lost the belay in her gree-gree. Swim team practice, case out of California, very important case where a woman was uh, terrified of diving. And so in competition, she always swam one of the last 3 laps of the relay team so that she did not have to dive. She had a fear of hitting the bottom and apparently could not do a good racing dive. And there was a circumstance at a meet where she was going to have to dive. And the coach set her off into a nearby pool to practice. And of course, she hit the bottom, hurt herself badly. So the issue is whether or not that was negligence on the part of the coach. And the court invoked this rule, the case was Kahn, K-A-H-N, this rule that I'm talking about now, that in situations where vigorous activity and involvement is required, simple negligence may be forgiven, including of instructors and coaches. This thing was even extended to a dance competition. Where it was not allowed recently was at some summer camp where a kid was hurt sliding down a banister. I mean, the court said that's not the kind of social utility that we're talking about. And another case where a solo biker hit something in a solid sidewalk in front of some business establishment. I think mostly because it was solo, the court said that's not going to qualify. Read this next piece from the Anglund case, New Jersey case that involved a snowboard collision. I'm just going to ask you to read it, and I'm going to back off here for a minute. All right, isn't that good stuff? I talk about this a lot. Maybe some of you have heard a talk I give called "The Law Says Yes to Risk." It's been going on for a little over 10 years, but increasingly we're finding the law being charmed by, if I can use that term, the social utility of what we do. And that utility is sufficiently great so the court says, okay, operator, we're going to cut you some slack. We know you can't do this without taking some chances and there being carelessness. Anyway, I'd like this a lot. All right, so ends the second part, which has to do with the primary assumption of risk doctrine. A little bit about a risk management plan. In one of our earlier abbreviated sessions, one of the questions had to do with where do I go to find a good risk management plan? And if you really want the best treatment of the topic, I would go to the WRMC, Risk Managers Conference website, and get into its library, because there's some marvelous stuff written by some of the best people in the business, including Drew Lehman at Knowles and Jed Williamson. I've got some stuff there. There's a wonderful textbook that I'm looking at now, written by Mike Gass and Simon Priest. Has a little bit of age on it, but it's still marvelous stuff, and I'm sure you can get it. Again, I've got some stuff at my website, but go to the internet and look for treatments of risk management plans, because there's a lot of material out there. You know, because my orientation toward this is managing the risk of legal liability, not operations risk so much. I tend not to try to get into that operation end of it, but inevitably I run across that in cases that I handled and consultations I get involved in. But my effort to boil all of this down has produced what you see here in part 3, a risk management plan. I mean, this is so simple, I'm almost embarrassed. But the first inquiry is, what can go wrong? In other words, given this activity, what can go wrong here? And some good outfits, I remember Knowles, when I was very active there a couple of years ago, began sunsetting, or at least investigating, each of its activity areas, hiking, climbing, whatever it was. And they would address each one, and part of addressing each one of those sort of afresh, the inquiry would be, okay, well, what can go wrong here? So you look at the activity. Let's take something really dumb. I'm going to leave the conference room and I'm going to walk to the deli and get a sandwich. What can go wrong? Well, I know 3 or 4 things that can go wrong. Second inquiry, how do you reduce the chances of it's going wrong? So once I've identified that I, might be hit by a car if I'm going to go to the deli for my office, how do I reduce the chances of that happening? Well, I stopped at the corners, I obeyed the lights, I've watched for cars. Anyway, you get the idea, and I apologize for the simplistic example. But what are you going to do? What can go wrong? How do you reduce the chances of it going wrong? And then finally, when it does go wrong, because something's going to go wrong sooner or later, what do you do? And that's an aspect of a risk management plan that often is overlooked. And that is, what do you do after the bad thing happens? Because mishandling there is as likely to produce anger and resentment and even liability, as likely to produce that as the original event. People who will forgive you for making a mistake will not forgive you for not cleaning up after it adequately or handling the activity results with a competent emergency reaction plan. So again, and this is a prelude to what we're going to do next, what can go wrong? That is, how can you affect the well-being of your client that's going to result in harm and maybe a claim? What can go wrong? How do you reduce the chances of it's going wrong? What can I do now? How can I plan right now to reduce the chances of that happening? And then finally, and this has to do with response and readiness, what do I do when it goes wrong? Can't be any simpler than that. And again, I've given you some resources. A lot of times when the pros are talking about, well, what is the goal of a risk management plan? Well, it's not eliminating risk, ever. It's managing risk and maybe being selective about the risks you're going to take. I remember Drew Lehman a couple of years ago told me his goal for Knowles was to eliminate serious accidents where people can get really hurt. So eliminate serious accidents, and then reduce the frequency and the severity of all the rest of them. I mean, I thought that was a marvelously clear reduce the chances and the severity of what's left. Okay, we're going to go into 2 silos. One silo is, I think it's called an anagram, but I'm not sure, deep grass. What can go wrong? The next silo is how you prepare for the thing that's going to go wrong, which is going to be clippers. So deep grass, what can go wrong? Where are you going to impact in a potentially bad way your relationship with your client? First is disclosures. What does the client deserve to know about you and what you're going to do and what the risks are? And what do you need to know about the client? Medical issues, for instance, any phobias that person may have, medical history that might be relevant. So deep grass is disclosures. Understanding the environment, environment. And by that, I don't just mean the kind of place you're into. I'm talking about the mood of the course, uh, just sort of the emotional health of the outfit. The second E, emergency response and follow-up. Something bad happens, what did you do? P, practices and policies, your own and others. What do you have in place as a guideline to how you people are expected to react if something bad happens? And in preventing that bad thing from happening, or at least reducing the chances that it might happen, your own prevailing practices and policies, and be really sensitive to your sacred cows, the things that you've done forever, because they may be the goofiest. Every now and then, have somebody with a clear head look at this and say, well, why in God's name are we still doing that? One program I was very active with for many years had this tradition of nude bathing. I know that sounds bizarre, but nobody had ever asked. It was such a clever, and I guess to some people, very enjoyable aspect of a course, but the prospect for embarrassment and putting people in perfectly miserable situations, I think should have been very clear. But again, it was one of those things that was so embedded in the culture of the outfit that nobody had ever said, why in heaven's name are we doing this? All right, gear. Good gear, good condition. People understand how to do it, and they use it for its intended purpose. Records, medical certainly, and importantly, records of what I'm going to call near misses and some people call incidents, things that have happened that ought to be put into a course log that will give you a tip-off of maybe some problems that are going to be coming down the pike. So records of performances of people, things, that is activities, and places. A little something about records that we sometimes don't think of. Administration, the staff are well paid, they're happy, the routes are well set, the gear is good, the food is good. I think people sometimes forget the value of a strong office up front for a good performance in the field. And then this last is a bundle of S's, but they're all important, and it applies both to staff and to your clients. The care you take in selecting these people, what kind of supervision you provide, and importantly, your policy for separating them, getting them the heck out of the picture if they're not competent and there's the danger they might hurt somebody. And again, that applies to staff and to students. All right, next slide is the second silo, and this is the being prepared silo. And it is clippers. And the first is contracts. Contracts with the people you're serving and with people who collaborate with you in serving them and people who provide you with gear or whatever so that you can better serve your people. Contracts, that certainly includes the release. Knowledge of applicable laws, this is the L. What laws apply to what you're doing? Federal, state, local. Insurance, you'd be a fool to operate without insurance. Be sure you understand that you've got the kind of insurance that you need. And you'll hear very complicated terms, I'm afraid, and be offered a lot of options, and just keep asking and asking until you understand what is going on. Directors and officers insurance gets some play, general liability insurance, the term additional insurance or additional insured. Be sure you understand this stuff. And if you don't, get your lawyer on the phone and ask your lawyer to help you. And frankly, if your insurance guy or gal can't make you understand this, maybe you're with the wrong person. Wise use of professionals. I've already mentioned insurance. Lawyers are important. Medical is important. And frankly, in this day when we are dealing with sort of a new brand of kid, it wouldn't hurt to attend a session or two on child development so that we all can understand better what it is we're dealing with. I think you'll find that the use of the term reasonable as applied to people, particularly the younger people we serve, is maybe a tough fit. Policies and prevailing practices. Know what other people are doing. Uh, you don't have to slavishly follow what the outfit down the river is doing, but you need to know what they're doing, and you need to understand why you're not going to do it that way. Uh, Policies and prevailing practices, uh, as I mentioned earlier, uh, if violated, can raise some evidence of your having acted negligently. So at least know what else is going on in the industry and be able to explain why you are varying from that. Emergency action plan. What you're going to do when the bad thing happens. What do you do to stabilize the group in the field? What kind of notices do you send out immediately? I include as part of the action plan a long-term directive as to how you deal with the families. I know outfits that will still send a family a note on the anniversary of a death or serious accident to a member of that family. Releases, we've talked about them. That could belong up in contracts, but then I wouldn't have an R. And then standards. Standards roughly are the same legal force as policies and prevailing practices, although if they have been well peer reviewed and they're well accepted and they're applicable and you have announced that you follow them, that can be a tough burden to overcome if you violate a standard. Now, I have a scenario here that I'm going to give you and ask you to read it. It's short, and it's basically a sort of a schoolyard sort of game gone awry. So I'm going to click next on the first half of the description, and then I'm going to give you some time, and then I'm going to go to the second half of it. And then I'll just discuss it a little bit with you because I don't think we are sufficiently interactive so that I can get feedback from you people. But this is an actual case, the Gamze versus Camp Sea-Gull. It came out of Michigan a couple of years ago. And it involved, as you will see, a children's game. So read away and I'll get back to you in just a minute. All right, I'm going to go to the next page and then I'll come back to this. Listener is the woman who hurt somebody. In just a second, I'm going to go back to the first half for a quick reread if anybody needs it. And in a second, I'm going to go down to the next half. Okay, duty of care owed, I would say clearly so. This was a camp, even if it was only a day camp. It certainly meets the relationship test, the intimacy of the staff and children in terms of control and trust. Foreseeability, some question about that. Should the people who laid out the course or were supervising it have foreseen that what happened or something like it might have happened? Let's leave that. Some of you will feel yes, some maybe no. But now about the next element of negligence. Was the duty breached? If we assume foreseeability was met and that the duty existed, was there a breach of the duty? Did the camp, which was sued, violate the duty that it owed to this child that was hit in the mouth by Leisner, who was running with this pole? So duty, yes. Foreseeability, maybe. Breach, did the camp act reasonably in these circumstances? There clearly was a loss, right? And the question then would be whether or not the teeth getting knocked out was the result of the camp failing to reasonably set up and monitor this game. Now, I'll tell you, my first reaction to this was, for heaven's sakes, let the kids play. I went immediately, I'm not proud of it, but I went immediately to this public policy related issue that I mentioned earlier, and that is we ought to be encouraging vigorous play. And to achieve that, we ought to acknowledge that not everybody is just going to act reasonably even all the time. And the court, the trial court that first heard this, said that that judge, couldn't find anything wrong. In other words, the judge said, well, what did the camp do wrong? And it wasn't clear whether, I'm sure he wasn't saying there was no duty. So he must have been saying maybe what happened here couldn't have been anticipated by the camp. Or maybe he was arguing that there was no causal connection between the injury and anything wrong that the camp did. Now, when it got to the appellate court, in other words, Gamze, the young woman who was hurt and whose family sued, not satisfied with the lower court, which basically tossed the suit out, appealed it. And the appellate court said that the lower court got it wrong, that there at least was a fact question as to whether or not the camp had adequately instructed the children and warned them of the flagpole flag not being the one to capture. In other words, it was sufficiently misleading to have a pole with a flag on it, even though there was another flag at the base of that, so that the staff should have warned and taken some precautions against somebody grabbing the flagpole. Interesting case. And so it's going to go back to the trial court, and I don't know if we'll ever hear about this or not, but if we do, I'll let you know. Now, as I say, this in games, you often have this issue of whether or not what happened is just the most inherent aspect of what could go wrong. There's another case recently involving a gym game in which everybody lies down in sort of a train. So person A lies down and then somebody else lies down in front of them above their head. And it's some deal where the first person that lies down holds the ankles of the second person. You get kind of a train going, and then they keep changing places. So you have 15 or 20, maybe not that many, changing places. In this case, somebody got hurt. The court ruled, look, if kids are going to do this and it looked like it was fun, somebody's going to get hurt. So let's just ease off and not get involved in this and find that anybody ought to be sued. A great case from the University of California where in a rope climbing, in a wall climbing course, it was instructional. And the instructors, professionals, had put the protection in a single crack system, which some would argue is the worst kind of negligence. According to the court, the mountain moved, but whatever happened, that single crack system gave up both sets of protection, and there was a fall, and somebody was badly injured. Court said, hey, this is wall climbing, this happens. You fall, it's an inherent risk, and he fell. Recent case, I think this was in Ohio, where a bunch of dads and their kids went on an overnight hike, and in crossing a stream, one of the fathers was standing on a rock in the middle of the stream helping the kids cross the stream, and he lost his balance and fell and hurt himself pretty badly. Again, the court said, hey, this just comes with the territory. Another case, though, involving a drowning in roughly the same kind of an outing, where the staff released the kids to go off on their own and a kid drowned. There was some question regarding supervision, an enlargement of what you would ordinarily expect to come from that kind of an outing. One of the first cases I remember reading was a lawsuit that came out of a relay race one morning on a school field, and a kid fell and broke his leg. There was a suit, and the court almost laughed the plaintiffs out of the courtroom. They said, kids have been falling since before they were walking. Kids understand falling. The other side tried to make something of the fact that the grass was wet with dew still. But again, the court just didn't take that seriously. Hope you'll have your own thoughts and reflect on what we've been talking about for the last hour as you review this case. Discuss it with some of your staff. See how you feel about this inherent risk idea. Understanding, for starters, what your duty of care is and the possibilities for relaxing that duty. Importantly, this concept of primary assumption of risks and the inherency of risks. I think you'll find some comfort in that. I found the assumption of risk doctrine extended to include negligence in activities of high social utility to be very affirming of what we and other AE outfits do every day. I've enjoyed this. Thank you very much. And again, if you have any questions, give me a call. I'd like to talk to you.